Idaho. This is the home of Coeur d'Alene, one of the most beautiful places in the nation. So the question is can or should officers ask for consent to search a vehicle even if they have probable cause? This question comes from an officer in South Dakota, and he says, look, I've seen it become a practice for some officers to ask a driver for consent to search their motor vehicle, even when the officer has probable cause to search. For example, the officer makes a traffic stop for speeding, establishes probable cause for, let's say, marijuana, where it's illegal in the vehicle, and then the officer still asks the driver for their consent to search the vehicle. Why are they doing this when they have an exception? Is there case law on this practice? Why ask for consent if you already know you're going to search a vehicle with probable cause? Look, it's an excellent question, okay? And there could be some differing opinions on this, but generally speaking, there is some value. I'll give you the pros and the cons. And first of all, the answer is yes, they can do it. Let me give you the pros and the cons, okay? Here are the pros of asking for consent, even if the officer is going to search the car anyway under probable cause. Number one, it gives the officer another reason to do what they're doing. So when the officer goes to court, or the prosecutor is justifying the officer's actions, the prosecutor can argue consent, and if that fails, let's say for some reason the consent is legally invalid, then we can move on to probable cause. So I always like cops to have multiple reasons for doing what they're doing. Number two is that sometimes the consent gives the officer more scope to search. A great example is when the officer has probable cause for open container, right? That is generally a very narrow, circumscribed type of search. I mean, you don't get the trunk, because it's not illegal to have open containers in the trunk. It's just you don't get to look in small coin purses, or maybe not even the sunglass holder. We can have a debate on that, but you don't really get those places, right? But when you ask for consent, generally the consent is pretty generic. Can I search your car for any contraband? That includes marijuana, drugs, and so forth. And that's another reason. The final reason is that prosecutors sometimes appreciate it, because if you have consent, then to search, it's just easier to articulate consent than it is to articulate probable cause. Consent is basically two requirements. Number one, did you get free and voluntary consent, right? Was it coerced? That's pretty easy. That just means that the person had a choice. Number two, did the consent stay within the bounds of any implied or express limitations? In other words, scope, right? That's pretty easy too. But probable cause, guys, it's just harder, because people have their own opinions about what probable cause is. Some judges say, yeah, this was probable cause for this, or they'll say, no, it wasn't probable cause. But consent doesn't require probable cause. It doesn't require that you believe that there's necessarily evidence in the vehicle, right, in most states. So that is why. Good question, and so forth. But let me talk about the cons. The cons primarily is a credibility issue, right? That's what I see the con. I see defense attorneys will bring out the argument, if, officer, you said you also had probable cause, right? Well, because let's say the search was conducted anyway, right? Let's say the driver says no, and the search was conducted anyway. And the officer's like, well, the defense attorney, so you had probable cause? Well, if you had probable cause, why didn't you just do it, right? Why are you asking my client for consent when you don't need probable cause under the motor vehicle exception? And here, all I got to say is, number one, have some confidence in what you're doing, right? Have confidence. The other thing is, explain what I just explained to you. You can explain, hey, look, there is a search and seizure instructor that teaches this. He likes cops to have multiple reasons for doing what they're doing. Consent is easier to articulate, and it also builds up good community relations. It looks better on camera that we're trying to talk to people, work with them, try to figure out what's going on, and so forth, all right? But there you go. There's your answer. I hope it helps. But either way, do what you feel is best, all right? All right. I just did a live roadside chat from Kootenai County. I'm going to do another one, because I got a lot of these I want to kind of catch up. So this question comes from an officer in the Army, okay? And he says, does a cat out of the bag search apply to digital evidence too? I'm gonna explain to you what a cat out of the bag search is in a second here, but let me give you his background. He says, I was watching one of your videos called cat out of the bag searches. So hopefully, if you're interested in that video, search it on the YouTube channel. And I was wondering if it also applies to digital devices. In the Army, we sometimes have family members of the service members bring us digital evidence where they saw, let's say, child pornography on it. Can we use a cat out of the bag search to justify searching without first seeking a search warrant? All right, the answer is yes, but let me kind of go into what's going on here, okay? Number one, what the heck is a cat out of the bag search? This is something that we at Blue to Gold call private searches, okay? We call these private searches cat out of the bag searches. It comes from a court case called U.S. versus Jacobson, United States Supreme Court, 1984. Okay. What happened in Jacobson is that a FedEx employee searched Jacobson's parcel they thought it got damaged. While in there, they saw cocaine. They called the DEA. They showed up, and the DEA opened the package again and searched it like FedEx did. Jacobson said this violated his Fourth Amendment rights because he had a privacy interest in the package. The U.S. Supreme Court said no, that no search occurred here because essentially, the way we teach it, the cat was out of the bag. The private search already relinquished the privacy interest. And as long as the police do not exceed the private search, then no search has occurred at all. Let's bring it to our digital devices. If a private person that is not the agent of government searches a digital device, let's say a USB drive, and finds child porn, and let's say that the person searching the digital device does not have common authority, meaning they have no right to let other people search it anyway. Let's say it's the girlfriend finds it on the boyfriend's hard drive and then takes that hard drive from the home, essentially steals it, and brings it to the police. The police then replicate the private search. Would that be permissible under the Fourth Amendment? The answer is yes, because the police are not exceeding the private search. Now, let's imagine that the girlfriend found the child porn on folder ABC. Police then look under the folder ABC, see the same thing. But they also see another folder called XYZ. And they open that up and they find evidence of credit card fraud. Would that evidence come in? The answer is likely no, because police cannot exceed the private search. See, the defendant, has not lost his privacy interest into things not searched by the private person. For those areas, the cop should go get a search warrant. Now, the final message here, okay? The answer is yes for my friend here, right? And the Army, federal rules versus the same rules for my cops under the Fourth Amendment. But just because you can doesn't mean you should. I'm okay from a legal point of view of using cat out of the bag searches for backpacks that have been searched by other people and so forth. But I'm not really good with this with digital devices. There's too much at stake. First of all, these are child pornography investigations. These result in potentially decades in prison. Digital devices have always caused a little heartburn with judges when cops search without a warrant because of the massive amount of data that digital devices can contain, especially like cell phones, right? So be careful with it. Now, let me give you one case example where I thought it was legitimate to search a digital device under cat out of the bag, under Jacobson. A Topeka officer got a call to a grocery store. A customer accidentally left his cell phone behind. The cashier then turned the phone on, like the screen, to see if there was any kind of identifying information. This guy put his child porn picture on the home screen. It's unbelievable, right? It's like these criminals want to get caught. Then, of course, seeing that, they turned off the phone because they don't want the phone to be remote wiped. The cop showed up, and the cop then turns the phone back on to see the picture, to kind of confirm what's kind of going on here. Is that a cat out of the bag search? The answer is yes, right? The answer is yes, because turning on the phone is viewed as a search under the Fourth Amendment. You are physically manipulating a phone to try to find information. That phone is not abandoned property, it is lost property. So lost property is protected by the Fourth Amendment. And so when the cop turned the phone on, that is a search. But it is a cat out of the bag search. The defendant here has no privacy interest in what has been seen by the private person. Now, if the officer exceeded that private search by going into the phone, looking at other pictures, that would violate Jacobson, and that evidence would be suppressed. Okay, we clear? All right, that's enough for today. All right, or not today, I might do another one later. But all right, thanks guys, keep them coming. If you have your question you want to ask, email me, go to bluetogold.com/show and give me your question.